Good morning, good afternoon, everyone. Welcome to this webinar and welcome back to those who joined us for part one, our seminar on this topic back in July of this year. In part one, we considered the issue of the proper law of an arbitration agreement with particular focus on what the Supreme Court might do in the case of Enka and Chubb, which was then before it. We tried to gaze into our little crystal balls and in an attempt to divine what the Supreme Court might do. And we finished that seminar with an expectation and a wish that the Supreme Court would at the very least provide some certainty in an area that had become somewhat of a muddle. About 6 weeks ago, on the 9th of October, the Supreme Court handed down its much awaited decision. And the primary focus of this session today is to look at what the court decided on this issue of the proper law of an arbitration agreement. We'll also seek to explore a little our hope as to whether some certainty has come or not as a result of the judgment. And we propose to break down this session into two main parts. In the first part, we will look in some detail at what the Supreme Court did decide and what it may not have decided. In the second part, we will look at some further discrete issues arising out of the Supreme Court's decision, including a very important underlying conflicts of law issue and what the Supreme Court's decision might mean for multi-tiered or escalation dispute resolution clauses, and also some practical drafting tips. We invite your questions throughout on the Q&A function, which is at the bottom of your screens. We will seek to answer them either as we go via the chat, via the same function, or orally if time permits. We should let you know this session is being video recorded, and the recording will be made available on the 39 Essex Chambers website by tomorrow morning. And it will also be sent to all of you by direct email when it's available. Very briefly, before we proceed with our session, permit me to do just a little bit of cross-selling. Many of you will know it's been years since we had a run of arbitration decisions out of the Supreme Court, but it's now like they're London buses and they're all coming at once. The long-awaited decision in another significant case, Halliburton, on conflicts of interest and so on, is due to be handed down by the Supreme Court on Friday. A star-studded ensemble of 39 Essex Chambers Council will be hosting a webinar on that case next Monday, 9:30 a.m. London time. So please do look out for further communications on that seminar. Now, getting back to our session, at the outset, I just want to take a moment to remind ourselves of why we're in fact here. When looking at a contract, any contract, particularly once the dispute has arisen as to its interpretation or the application of a term, or indeed the very existence and validity of the contract as a whole, we need to apply a system of law to the examination of those issues. Now, different systems of law take different approaches to determining what that applicable law should be, albeit it's fair to say that overall there's not a huge discrepancy in approach between different systems of law. But the issue as to the applicable law needs to be considered in the context specifically of arbitration agreements, since by reason of the doctrine of separability or severability, at least for some purposes, arbitration agreements are regarded as having a separate existence from the contract of which they form a part. That means they can have a different law that applies to the sorts of questions that one asks about contracts. Now, the matter of the proper law of agreement is vital, in particular when it comes to considering issues, or potentially vital, when, and we'll touch on this in our seminar, when one comes to consider issues such as the existence, validity, effectiveness, scope, interpretation, and substantive application of an arbitration agreement. It will include matters ranging from whether or not a party originally not a signatory to an arbitration agreement or to a contract containing an arbitration agreement can be bound by the arbitration agreement. It will include matters such as whether, where there is a multi-tiered dispute resolution clause, whether the provisions of that, the prerequisites to arbitration in that are mandatory. And if they are, what degree of compliance might be required to them. And it might also be relevant to the extent to which a tribunal can deal with a very badly written arbitration agreement. And it may also, in the case into which we are deep diving today, demonstrates, it may determine whether or not a court ought to grant relief in respect of an arbitration agreement, and specifically whether or not it should grant an anti-suit injunction to stop proceedings in a foreign place. Now, in Enka, the Supreme Court, as we will hope to show, provided at the very least useful guidance on all of these points. Now, we'll come to the substantive part of this session, and to lay set out the context of the much more intellectual comments that have come from my colleagues. I just want to set out the facts of the Inca case and how the issue arose. The case itself involved a claim under a construction contract in respect of a catastrophic fire at a power plant in Russia. There have been various subrogations and assignments, so the status in which the parties were suing has become a little bit obscure. But ultimately, one party, Chubb, commenced court proceedings in Russia under the contract, seeking a finding of liability against another party, Enka. Enka commenced an arbitration claim in the courts of England, contending that the construction contract contained an arbitration clause providing for English arbitration, and Enka sought an anti-suit injunction to restrain the Russian proceedings. Enka also started an English seated arbitration. At first instance, the anti-suit injunction was rejected. On appeal, it was granted. And the decisions at those levels turned on matters relating to the validity and the scope of the arbitration agreement and the preliminary question of which law was to be applied to determine those questions. Was it the law of the main contract? And if so, what was that law? Was it the law of the arbitration agreement? And if so, what was that law? Or was it some other law? And what might be the relevant considerations? Now, all this came before a very, very impressive Supreme Court bench of 5 judges, including some of the leading commercial and contract lawyers in the English jurisdiction. The judgments, all the judgments are, I think, superbly written. Some of the clearest and plainest legal language one could hope to achieve. They're a real tour de force in that sense. But the real point of this seminar now is to turn to what the Supreme Court actually decided. And Stephen's going to kick off here.
Thank you very much, Ben, for that introduction. Now, many of you will be familiar with the highlights of the Supreme Court's decision. That the decision was split 3-2, and the majority upheld the Court of Appeal decision, but on different grounds. Now, this may sound like there continues to be a multiplicity of views in the area, and this area of law remains as confusing as it was. The Supreme Court disagreed sharply with the Court of Appeal's reasoning, and I will come back to this. However, the 3-2 split in the Supreme Court is much less divided than it sounds. The majority and minority agreed on more than they disagreed. There are really 2 key points of departure between the minority and the majority. And these are the implication of the implied law of the main contract in the absence of an express choice of law clause. And it's important to remember that there was no express choice of law for the main contract in the Enka and Chubb case. And note also that this is a difference, not on principle, but only on application of principle. It was on the facts that the minority took a broader view of the implication of the implied choice of law than the majority. But they didn't actually disagree with the principle on this point. The main point of principle on which the minority disagreed with the majority was on the choice of law with the closest connection, should you get to that stage of the test. The majority favored a default choice of law of the seat. The minority did not agree with the default choice and held in most cases the arbitration agreement would have the closest connection with the main contract law, however determined. And that included a determination of the main contract law as the law with the closest connection. We should also bear in mind that the split was caused or came about because of some rather uncommon facts of the case. As I mentioned, there was no express choice of law in the main contract. And it was only because there was no express choice of law in the main contract that the implication of implied law for the main contract became relevant, obviously. And also, it was because of the absence of an implied choice of law for the main, for the arbitration agreement, that the law of the closest connection became relevant. And this is important to bear in mind because all 5 judges agreed on the answer if the situation had been that there was, in fact, an express choice of law in the main contract. And they agreed that an express choice of law for the main contract would either be an express or implied law of choice for the arbitration as well. Therefore, the Supreme Court decision settles the position for what I think would be the majority of cases where the main contract contains an express choice of law clause. It settles the debate that we discussed the last time between Sul America and actually the Court of Appeal in Enka and Chubb, where the English courts had been vacillating between applying the choice of law of the main contract or the law of the sea. And this issue should now be settled by the Supreme Court decision, which finds that where there is an express choice of law, then that express choice of law in the main contract would apply to the arbitration agreement contained in the main contract, either as an express choice of law in the arbitration agreement or as an implied choice of law. The majority took a broader view on the express choice of law clause in the main contract and indicated that it is likely to be an express choice of law for the arbitration agreement as well, as we saw in the Kebab, G, and Cup case. I think on the basis of this authority, we could see more cases finding that the express main contract law is the express choice of law for the arbitration agreement as well. And that would go some way in settling the law in this area. So I've mentioned that the court agreed on more than this, they disagreed. So what did they agree on? Well, all 5 judges agreed that the law of the arbitration agreement is determined by applying English common law rules for resolving conflicts of laws rather than the Rome I regulations, because arbitration agreements are excluded from the Rome I regulations. And that the law to be applied to the arbitration agreement will be, firstly, the law chosen by the parties to govern it, and this will be either express or implied, or in the absence of any choice, the system of law the arbitration agreement is most closely connected to. It's important to note that both the majority and minority found that there is no difference between an implied choice and an express choice. An implied choice is said to be still a choice which is just as effective. Whether the parties have agreed on a choice of law to govern the arbitration agreement is ascertained by construing the arbitration agreement and the main contract as a whole, applying the rules of contractual interpretation of English law as the law of the forum. Now, this is one of the points which we'll come back to discuss in the later part of this webinar. The court also agreed it is generally reasonable to assume the parties intend or expect the contract to be governed by a single system of law. And to apply different systems of law to different parts of a contract has the potential to give rise to inconsistency and uncertainty. And that's one of the reasons why the court agreed that where there was an express choice of law in the main contract, this is most likely to apply to the arbitration agreement as well. And the court was quite clear that the choice of a different country as a seat of the arbitration is not without more sufficient to negate an inference that the choice of law to govern the contract was intended to apply to the arbitration agreement. So that clearly settles the dispute between the South America line and the line that at that time culminated with the Court of Appeal decision in Enka and Chubb. I should also mention this because I've committed myself in writing that English law should adhere closer to the international position in the New York Convention. And I'm pleased to say that all 5 judges also agreed on the application of the validation principle. And this might have been implied in some of the earlier decisions. And I think Ben and Niraj would discuss that shortly after this. And so they found that the application of the law of the contract to the arbitration agreement may be negated by the validation principle. And this explains quite a number of cases, including the South America case. And this would apply where the existence of there is a serious risk that if governed by the same law as the main contract, the arbitration agreement would be ineffective. The majority also found that the application of the law of the contract to the arbitration agreement may be negated if the law of the seat provides that when arbitration is subject to that law, the arbitration will also be treated as governed by that law. An example given in the judgment is of the Swedish Arbitration Act or Section 6 of the Arbitration of Scotland Act 2020. I don't think there was actually a difference to the minority on this. The minority was simply silent on this. So we don't know that the minority did not agree with this. I mentioned that I would come back to the Supreme Court's disagreement with the Court of Appeal's reasoning. The Court of Appeal's decision mainly hinged on a finding that there was a close connection or overlap between the law governing the arbitration agreement and the law of the sea. The Supreme Court found, and again, all 5 judges agreed here, that all of the provisions of the Arbitration Act 1996 relied on to support the overlap argument. That is, that there was a strong connection between the Cural law and the law of the arbitration agreement, were in fact non-mandatory. And in fact, where the arbitration agreement is governed by a foreign law, which the Arbitration Act expressly allows, by reason of Section 4.5 of the Arbitration Act, the non-mandatory provisions of the Act which concern arbitration agreements do not apply. The Supreme Court therefore found the Arbitration Act contemplates and specifically provides for a situation in which the arbitration agreement will be governed by a foreign law, even though English law governs the arbitration agreement, the arbitration process itself, and therefore no inference can be drawn that by choosing an English seat and within English law as the Cural law, parties are impliedly choosing English law to govern the arbitration agreement. Let me come back a little bit to some of the finer points of disagreement between the minority and the majority. The majority favored the law of the seat as the law of the closest connection because this was consistent with international law embodied in Article 5.1a of the New York Convention, and which was enacted into English law in 1032b of the Arbitration Act. They recognize that the first limb of Article 5.1a includes an implied choice, and the majority also recognize the New York Convention is to be interpreted to apply the same conflict of law rules to Article 2.3 of the New York Convention, which deals with recognition of arbitration agreements. And the majority therefore found that the same choice of law rules should apply, whether it is pre-award or post-award. The majority also found that the same choice of law rules should apply to the scope of the arbitration agreement as much as to the validity, and this also flows from Article 5.1c of the New York Convention and Article 1032 of the Arbitration Act. This is a point which the minority specifically did not agree with. I mean, I have to say that I think the majority's, I favor the majority's position on this. They found that the general approach in the conflict of laws adopted by the common law and the Rome I regulations is to treat the validity and scope of a contract, as well as other issues such as the consequences of breach and ways of extinguishing obligations as governed by the same applicable law. They said this made good sense, not least because the boundary between issues of validity and scope is not always clear, and it is logical to apply the law identified by the conflict of law rules prescribed by Article 5.1a of the New York Convention and Article 103b of the Arbitration Act to questions about the scope or interpretation of the arbitration agreement, as well as disputes about its validity. As I said, I agree with the majority view, and I think this is actually consonant with Article 2.3, which is enacted as Section 9.4 of the Arbitration Act, which requires the court to recognize and enforce an arbitration agreement unless the agreement is null, void, inoperative, or incapable of being performed. While not express, the scope of the arbitration agreement must be included. Because if the arbitration agreement did not extend to the dispute, then the court need not stay in favor of arbitration. Therefore, the same governing law and the same means of determining that governing law should be applied to the scope as much as validity. One point that the majority left open was whether the validation principle applied in the situation where one has to determine the choice of law by the closest connection test. This is the point where, in my view, I think the majority decision, which actually hews quite closely to the international position, and I have to applaud the majority for the way in which they dealt with the New York Convention and bringing English law in line with the New York Convention. This is the point perhaps where I think that slightly departs from perhaps how this might be dealt with in the international position. In the international position, the approach is likely to be that you hardly ever get to the closest connection test, because in most instances you would imply the choice of law. And in fact, one of the points about the validation principle as applied in the international position is that you would assume, it is implied that the parties would have chosen a choice of law that would validate rather than invalidate the arbitration agreement. So in some sense, I think, if one marries the broader approach that the minority took to implying a choice of law, with the majority's position, you get to a position which is actually very, very close to what is seen as the international position on the choice of law of an arbitration agreement. The one final point I'll mention is that the majority also found that the fact that the contract requires the parties to attempt to resolve a dispute through good faith negotiation, mediation, or other procedure before referring it to arbitration will not generally provide a reason to displace the law of the seat of arbitration as the law applicable to the arbitration agreement by default in the absence of a choice of law to govern it. I mentioned this point because this will be one of the points that we will be picking up later in the later part of this arbitration as well. Now, let me hand over to Philippe, who's going to talk about some of the undecided or unresolved points remaining from the Supreme Court decision.
Thank you, Stephen. I'll be very brief because Stephen has covered some of these, and then the remaining 4 points we'll pick up in detail in part 2. So 7 main points that are either undecided or entirely unresolved following this decision. The first is whether the provision within, say, the law of the seat may displace the operation of the law of the main contract, which is the point that Stephen has already touched on. The majority gives the examples of the Swedish Arbitration Act and the Scottish Arbitration Act, and both of those provide, in summary, that in the absence of a choice of law, the arbitration agreement will be governed by the law of the seat. And as Stephen said, this wasn't so much a point of disagreement, but simply something that wasn't directly an issue, and I think is fair to describe as an obiter comment in a couple of paragraphs by the majority, and then simply not addressed by the minority. And it may matter in future cases. The second point is the impact of Rome 1 on the reasoning. And as Stephen said, the decision is very clear, and both my majority and minority, that the approach that is being formulated is an English approach. What could become interesting in future is if at any point in the future, the Rome 1 choice of law rules also fall away, and there is at least a partial return to applying common law rules to the identification of the law of the main contract, we may find that certain decisions may again be decided differently because of the change in the mechanics. Probably in a case like this, it wouldn't have made a huge difference because it was a a sort of a question of implication, but in other cases, the choice of law regime within Rome 1 can be quite mechanical, and the common law doesn't operate in that way. So that may be a space to watch as well. The third point, which Stephen has touched on, is whether the law or the proper law of the arbitration agreement covers both validity and scope, or only validity. And there is a degree of disagreement on that. And Stephen has already gone through that. But what I would say about it is that the majority takes quite a principled approach about recognizing the difficulty of separating validity and scope and seeing them as going hand in hand, whereas I might say the minority's view is a bit more literal or textual when looking at the Arbitration Act and the New York Convention provisions. That brings us really to a brief introduction of the 4 topics that we'll pick up in detail in part 2. The first is, where exactly does the choice of law regime come in? And that takes on a particular importance when you're dealing with arbitrators, perhaps an ICC arbitration, which is English seated. It isn't obvious that the English law of the forum approach, which was adopted in Enka, should apply, but we'll go into that in more detail. The next one is multi-tier dispute resolution clauses. Again, only touched on briefly by the Supreme Court, and there's quite a bit to discuss there. And we'll also look at the question of whether Enka, being a decision based on an arbitration clause contained, or dispute resolution clause contained within a main contract, whether it would make any difference if it had been in a freestanding agreement. And then we'll finish off with drafting. And I now hand over to Niraj and Ben to take us through some of the previous cases and see how the difference in approach in Enka might have affected the outcome there.
Thank you, Philippe. So in Lord Borough's words at paragraph 245 of the judgment, he said, "It is very difficult to rationalise all past cases." We see that as a bit of a challenge. We thought it might be worthwhile to apply the principles set down by the Supreme Court in Enka retrospectively to see how some of the earlier conflicting cases might have been decided if they'd been decided differently, and to maybe impose some order on those previous cases. We're going to look at some cases in England. The first up is Sul America and Enesa, which is referred to extensively in the Supreme Court's judgment. The Sul America case was decided in 2012, and up until now it has been the leading court of appeal authority on determining the proper law of an arbitration agreement. In Sul America, there were two insurance contracts which were expressly governed by Brazilian law. The dispute resolution clause in those contracts provided for a London-seated arbitration. In that case, the Court of Appeal decided that there was no express or implied choice of law, and the law of Brazil would have applied to the arbitration agreement when determining its scope and validity, but that was a problem. So they looked at the law with the closest connection and decided that English law had the closest connection to the arbitration agreement, and that's because that's one way of looking at the Sul America case, is that applying Brazilian law, which on the face of it would have applied to the contract, everywhere else in the contract it was in Portuguese, all the actors were Brazilian, and the express choice of law for the main contract was Brazilian law. That would have led to a serious risk that the arbitration clause would have been held ineffective. But that wasn't the basis on which the Court of Appeal decided that case. They found that the closest connection, or the closest connection test, was triggered, and the law of the closest connection was English law. I think now it would be fair to say, looking at Enka, it would be fair to say that the law of Brazil probably was presumed to apply to the arbitration agreement, because there was an express choice of Brazilian law. But because of the serious risk that Brazilian law would undermine the arbitration agreement in Sul America, the presumption in favour of Brazilian law was rebutted, and by implication, the law of the arbitration agreement was the law of England and Wales. So in some ways, the elephant in the room was the validation principle, and the Supreme Court in Enka has revealed the elephant in the room. And instead of looking at Sul America now as a closest connection test, which was quite a contrived argument in many ways because of the factors I've mentioned and the reasons why most of the factors pointed towards the closest connection being Brazilian law. It's now possible to rationalize the Sul-America case. The other cases I'll briefly touch on are XL Insurance and C&D. They're both decisions from England. XL Insurance is from the High Court in 2001 and C&D is from 2007. It's a decision of the Court of Appeal. Both of those cases involved insurance policies which were governed by New York law but provided for a London-seated arbitration. The problem for the insurers in those cases was that New York law was said by the insured to govern the arbitration agreement, and according to the insured, the Federal Arbitration Act applied to invalidate the arbitration agreement. So the insurers wanted to argue that English law or some other law applied to the arbitration agreement, not New York law, because that would have invalidated the arbitration agreement. In XL Insurance, Mr. Justice Toulson held that that English law was impliedly chosen to govern the arbitration agreement, and he referred to the fact that the arbitration agreement incorporated reference to the Arbitration Act 1996. But of course now, according to Enka and the Supreme Court, such a reference to procedural law by itself isn't sufficient to negate the presumption that the law of the main contract will apply to the arbitration agreement. So now the XL case and indeed the C&D case can be interpreted or reinterpreted as demonstrating the validation principle at work. So again, there was an implied choice, but not for the reason that Mr. Justice Toulson in XL Insurance or the Court of Appeal in C&D decided. Instead, it's the validation principle that can now be seen as resulting in the conclusion that the validation, that New York law couldn't have applied to those contracts. It must have been English law. And finally, we have the decision of Mr. Justice Andrew Smith in Arsenovia. In this case, the main contract was expressly governed by Indian law with a London-seated arbitration. In that case, it's quite similar to Sul-America in that sense, but Sul-America was distinguished and Indian law was held to be the proper law of the arbitration agreement. This again fits with the principles from the Supreme Court because there's no serious risk of invalidation. It's not as if applying Indian law would have invalidated the arbitration agreement in Arsenovia. The law of the main contract, of course, will now usually be the law of the arbitration agreement, absent such a serious risk or other factor. So again, the Supreme Court's reasoning in Enka now helps us to revisit and review Arsenovia in light of that. And it also avoids the tortuous or forced reasoning of some judges in trying to choose a different law because instead of mentioning the elephant in the room, they have tried to fit their determination of the law of the arbitration agreement within the previous test that was set down in Sul-America, or to try and distinguish Sul-America. I'll now hand over to Ben to deal with the case of Kebabji.
Thanks, Niraj. Kebabji, of course, was one of the cases we dealt with in our previous seminar. And those who joined us for that or who are up to speed with the English cases will know that almost certainly the most interesting feature of this case is not what it says about arbitration, but like the Dallar real estate case of 10 years ago, the most interesting feature is that it demonstrates a sort of battle between the courts of England and France, whereby they are coming to different conclusions on essentially the same issue at the same time. This battle may go up to the superior courts in both jurisdictions. And if it does, watch this space for our next seminar. But for present purposes, we can probably rest with the observation that the Supreme Court would almost certainly fully endorse the approach that the Court of Appeal reached in Kebab. I mean, in many ways, Kebab was a very straightforward case. The main contract included a provision that stipulated that the agreement shall be governed by and construed in accordance with the laws of England. There were further provisions in the main contract that were at least consistent with this choice of law clause extending to the arbitration agreement. And perhaps somewhat unusually, but tellingly, the arbitration clause itself included an express stipulation that the tribunal was to apply all provisions of the main contract. Now, the Court of Appeal had little hesitation construing that multiplicity of express provisions as containing an express choice of law for the purposes of the arbitration agreement, notwithstanding that the arbitration was stipulated to be seated in France. Now, at the time it came out, or in the aftermath of it, the Court of Appeal's decision in Chubb was described by some commentators as representing the outer limits of what was permissible in finding an express choice of law in a main contract that governed as an express choice in the arbitration agreement as well. However, I suspect that in light of Enka, Chubb will be seen as being entirely orthodox and not at all heterodox. It will be seen in light of what I see as the sentiment of the majority, that a generous construction be given to finding that an express choice of law in the main contract also constitutes an express choice of law for the purposes of the arbitration agreement. Niraj?
Thank you, Ben. So I think just in summary then, looking at those cases, those recent cases, we can conclude that the Enka decision does impose some order on the earlier cases, and it's the elephant in the room again, and in enacting the validation principle expressly, it still means that we may get disagreements, just as in Enka, the Supreme Court was split in the sense of how to get the answer of the correct proper law of the arbitration agreement, whether it's an implied approach or whether it's the law of the law which has the closest connection to the arbitration agreement. So there may still be disagreement, but I think Enka whittles down the scope and the areas for that disagreement. We'll now move on to the second part of our webinar, and we will look at the key issues that remain unresolved or undecided, and we'll take more of a discussion-based approach for the second part.
Thanks, Stephen. We start with you again.
Thank you, Ben. So one of the issues which I mentioned in my introduction of the decision is the application of English law, or the English law and contractual interpretation as a law of the forum, to determine whether the parties expressly or impliedly agreed a choice of law in the arbitration agreement. The Supreme Court agreed that the arbitration agreement is to be construed according to its proper law. But in deciding whether or not there was a proper law that had been agreed by the parties, the Supreme Court said that they would apply English law, and particularly English law contractual interpretation, as the law of the forum. I think this does raise a question as to whether it is a slightly, at least to my view, a somewhat parochial approach. But let's put that to one side, because as I mentioned, all 5 judges in the Supreme Court agreed with that. I think there is an open question, though, as to whether an arbitrator sitting in England is required to apply English law or English rules of contractual interpretation as a law of the forum, if they have to determine whether the parties had agreed either expressly or impliedly a law for the arbitration agreement. I think there's certainly there's scope for an arbitrator to take a different view, because under Section 34(2)(f) of the English Arbitration Act, an arbitrator can decide whether to apply strict rules of evidence or any other rules as to the admissibility, relevance, or weight of any material, oral, written, or other sought to be tendered on any fact or opinion. I think there's definitely scope for an arbitrator to take a different view. If I can just take a less parochial view as well and look more broadly, if we look at the model law, which applies in Singapore and many other jurisdictions, I think there's even more scope to say that an arbitrator can choose to apply a different law or a different choice of law than applied in that jurisdiction. Article 28(2) of the model law which deals with the substance of the rules applicable to the substance of the dispute, says that the tribunal may apply to the law, it may apply the law to determine by the conflict of law rules which it considers to be applicable. So it clearly allows the tribunal to determine what conflict of law rules they want to apply. And Article 19.2 says the tribunal has the power to determine the admissibility, relevance, materiality, and weight of any evidence. But I think this is, it does have some significance, and it is, I think, a bit of an unresolved point, not just in England, but also in Singapore. In Singapore, one of the leading decisions on the proper law of the arbitration agreement was the Court of Appeal case of BNA and BNB. And in that case as well, and I've written about this also, the Court of Appeal applied Singapore law in construing the arbitration agreement. In that case, the question was not so much whether a proper law had been agreed, but really what was the seat that had been agreed. And it was specifically raised to the Court of Appeal that an arbitrator in Singapore need not apply the Evidence Act because it doesn't apply to arbitration proceedings, and therefore, arguably, the arbitrator wasn't bound by the parole evidence rule, which is encapsulated in the Evidence Act in Singapore. The Court of Appeal rejected that argument and said that that only applies in arbitration proceedings, and it doesn't apply to court proceedings which flow up from arbitration proceedings. I had some difficulty with that, and I think this issue still needs to be resolved in the court. The potential conflict between how an arbitrator may approach the construction of a clause and how the court would. I think there is still an argument for the application of internationally accepted principles of construction, which give effect as much as possible to the pro-arbitration policy of the New York Convention in determining whether the parties had agreed on the proper law of the arbitration agreement. I do recognize that it is important for arbitrators to apply the same. Sometimes it is important for arbitrators to ensure that the decision that they reach would be upheld in the court, in the seat court, and also in courts in which the award may be enforced. And this raises the question as to whether they should apply the same principles as, for example, the seat court. But then that leaves the question open as to what about the principles applied in the court of enforcement. I think practically applying internationally accepted principles of construction would usually arrive at a similar conclusion. I don't expect a markedly different conclusion. There may be some issue over whether you can refer to pre-contractual material in those jurisdictions which the parole evidence rule applies. But these are my thoughts on the issue. Let me hand it over to either Ben or Niraj to see whether they've got different thoughts.
I think I only have one observation here, and perhaps I betray my background as an English contracts and conflicts lawyer. I must confess, I hesitate a bit at the notion of an internationally accepted approach to construction of anything. I just think the difficulties in discerning what that might be in any case might outweigh the advantages of an internationalised approach. I take on board the concern that having a court in the forum or an arbitrator sitting in a particular place, starting from the proposition that the conflicts laws of the forum apply to the very first question of how does one work out what the applicable law is. I take on board that could be parochial, but the counter to that is you have to start somewhere. And I don't think it is terribly parochial or terribly problematic that one starts with the law of the forum or the law of the seat in asking that question. Now, it may be that the law of the seat is too parochial and may need to change over time. But where, as a matter of English law, the question is usually asked in these terms, if the contract was valid, what would the proper law be? So what is the putative proper law? I don't see that is a particularly parochial approach. And in many of the cases, courts in England, courts in Singapore have approach the question of determining what is the proper law of an arbitration agreement from the conflicts law viewpoint of a foreign country. For example, in BCY and BCZ in Singapore, it was in fact, although it's not clear from the judgment, an Australian arbitrator sitting in Singapore applied New York law to decide whether or not an arbitration agreement had been concluded by virtue of pre-contract negotiations. So that was very much a case where a very international context, but applying essentially a local conflicts rule, but in a very international way. Niraj, did you have anything to add on that, or shall we move on?
No, just very briefly, I think Stephen makes a very good point, and Ben as well. I agree with what you say. If an arbitrator sitting in England, then I imagine you'd follow the principle of Enka when determining the law of the arbitration agreement, because you want your award to be upheld at the seat. But I agree that there is room for doubt there, maybe that the law will still develop in this area. I'll now hand over to Philippe, who'll talk about multi-tier dispute resolution clauses.
Niraj. The interesting thing about this is the sort of simplicity of the majority's analysis. Sorry, it's actually not even the majority, it's Lord Burroughs. It's a point that's touched on by Lord Burroughs in his separate minority judgment in 2-3 paragraphs. And essentially what Lord Burroughs suggests when you're dealing with multi-tier dispute resolution clauses is that you start at least from a presumption that all the components of that multi-tier dispute resolution clause are to be governed by the same law. And there's an obvious attraction to that simplicity if there are negotiation or mediation obligations that come before arbitration. But there are also concerns about that approach, because depending on what ultimately the proper law of the arbitration agreement is, such obligations perhaps to negotiate in good faith or to mediate first may be alien to that system of law, or the relationship between such dispute resolution mechanisms and arbitration may become unclear, and it may become problematic to decide whether those are strictly enforceable preconditions to the ultimate obligation to arbitrate if there's no resolution, or whether they create a tension between non-arbitration and arbitration and may actually pose a risk to the enforceability of the arbitration clause, which is probably not at all what Lord Burroughs would intend by having everything governed by the same proper law. So my suggestion would be that a more sort of fact-sensitive construction approach is required, and that there's clarity about the proper law governing the arbitration agreement following Enka, at least where subject to the sort of prior point about is that set of rules even applicable when you're dealing with an arbitration rather than a determination in the seat course or the court of enforcement. But I think with those sort of opening observations, I'll hand over to Niraj, who has some further thoughts on this.
Well, I just have my eye on the clock, and we'd like to get on to some drafting tips, as Ben introduced earlier. So if it's okay, I'll look at freestanding arbitration agreements and just say something very briefly about those. These are also known as submission agreements. Supreme Court, and again, in particular, Lord Burroughs very, very briefly touched on freestanding agreements. And it's very clear that the decision in Enka doesn't deal with the situation where you have a freestanding arbitration agreement. There will be different principles that apply. We don't actually know exactly what the Supreme Court's views are on which principles will apply. We'll have to wait for the right case to come along. But again, just digging into submission agreements, you either have those, they're separate to the main contract, and you either have those at the same time the main contract is entered into, which I think is very rare, or more likely you have them after a dispute has arisen and the parties agree to arbitrate. I think this is perhaps more of a theoretical question than a practical question. Often when a dispute has already arisen and parties are looking at dispute resolution and looking at arbitration, one would think that they would have their eyes quite firmly on the validity of a clause and how to, or how that clause is to be determined. So I'm not sure the situation is really going to crop up. One question though, one thought to throw out there is it satisfactory, as suggested by Lord Burrows, that there might be a difference in the approach to determining the proper law of the submission agreement depending on when that agreement was entered into? I think it's probably right to say that, because English contract law principles and interpretation principles provide that you interpret the agreement at the time it was entered into. You don't look at the party's conduct subsequently. So it may well be that a submission agreement entered into at the same time as the contract, the main contract, could well be interpreted differently, and the proper law could be different to a submission agreement entered into many years later, when there's more of a background and a history to the parties' relationship, and it may be that you have a different test that will apply. But overall, it is rare to have submission agreements, and I don't think it's surprising that the Supreme Court did not focus very much on this issue, because it didn't come up for decision. I don't know if anybody would like to contribute on submission agreements before we move on.
Yeah, I think briefly, I fully agree, Niraj, that they are quite unusual. And I think one problem is Enka doesn't really lend any clarity to this, because the premise of the decision is really the indivisibility for present purposes rather than questions of validity between the main contract and the arbitration agreement, and taking that as your starting presumption. I think if we think, as you've already introduced, about the multiplicity of situations in which you might get a submission agreement or a freestanding arbitration agreement, that sort of reasoning doesn't carry across. And I thought I'd just give two further examples. One is perhaps where shortly after the main contract, a dispute resolution provision is also agreed between the same parties and without any material developments in between. In that sort of situation, it would seem that the logic of Enka is quite sensible, and that it might have just been a drafting oversight to not specifically provide for the governing law in that sort of agreement. But for example, if you have a submission agreement where there are a number of contracts between those parties, and for example, the governing law of those individual contracts differs, because some may deal with construction aspects, others may deal with financing under yet a different governing law, the sort of simple approach that we now have, or relatively simple approach in Enka, doesn't carry across. So I think definitely a lot of room for debate on that.
We might end up with some brief comments on some practical implications of the judgment for advising and drafting. But while we're sticking to the more intellectual aspects of the topic, we might just address a couple of the questions that have come in, for which we're very grateful. One of the questions is would there be any impact on our views, or perhaps on what the Supreme Court might have said, if the seat was decided by an institution rather than by choice of the parties? Would any of the three of you like to take that on?
Okay, let me try and kick this off. I think it is an interesting question. Well, answering the question point blank, I think the answer is yes, because the Supreme Court's decision was actually based on the fact that the parties had chosen a seat. And if the seat was chosen by an institution, then they might well take a different view. However, we should bear in mind, though, that you rarely get to the point where you have to apply the closest connection test, which is when the seat law then becomes relevant. If there is an express choice of law in the main contract, then that express choice of law, save for the validation principle, or where the law of the seat expressly provides otherwise, the law of the main contract is likely to apply. I could conceive a situation where you have a very, very bare arbitration clause, which simply says perhaps that the parties agree to arbitrate and don't state any seat, governing law, rules, or anything else. Then there's a lot to fill in. And possibly, yes, in that situation, you may have to, it may come to a question of what is the governing law of that arbitration agreement. And if one applies, what's the position in the New York Convention, then you get to the default position of the seat anyway. And in the New York Convention, I don't think it matters whether the choice of the seat was by express agreement of the parties or by designation of institution. The New York Convention leaves a simple default provision. Is if you can't find either an express or implied in agreement or intention on the law of the arbitration agreement, then you apply the law of the seat. So I think you would get to an answer in any case. The route you get there might be slightly different, but I think you would get an answer. Does anyone else have something to add to that?
Just a short observation. I mean, much of what we've been considering has been ultimately a question of contractual interpretation. What did the parties intend to be the law governing their arbitration agreement? And if that intention of the parties has to be determined at the time of contracting. So if the seat is determined by an institution and not by the parties, and if it is determined some time after the parties reached their agreement, then the fact that an institution has designated the law of the seat ought not say anything at all when it comes to the question of trying to construe the contract to give effect to the party's intention. So I don't think we get into the realm of Enka and most of the cases we've considered at all, but we still have to come up with a law of the arbitration agreement. And as Stephen said, there are mechanisms beyond the intention of the parties for allowing us to come up with a law of the arbitration agreement if there is no way of discerning an intention on the part of the parties.
We have another question, and that question was, did the Supreme Court say the law governing an arbitration clause in a contract with an express choice of governing law for the contract, but no separate governing law clause for the arbitration clause, would be the same as the rest of the contract due to an express choice, an implied choice, or closest connection? And could that be material in a case? I'm not sure I understand the exact point of the question, but let me kick off by answering it as best I can. The Supreme Court did say that where there was an express governing law for the contract, then in almost all circumstances, save for the validation principle, and as I mentioned, where the seat law of the seat provides otherwise, that law will apply to the arbitration agreement, either as an express choice or an implied choice. And the court did say that it really doesn't matter whether it's an express choice and an implied choice. The court said that there is no difference between an express choice or an implied choice for this purpose. And an implied choice is just as effective as an express choice. The court also did say, in the course of the reasoning in its judgment, that it would assume that the parties intended one system of law to apply to the entire contract. So you would also, I think, find that there would be a strong reasoning to find that the same choice of law applies to the entire contract, and rather than just parts of it. I mean, there was some discussion in the judgment as to the principle, I think, of depassage. I think that's how you pronounce it. The idea that you could have different choices of law applying to different parts of the contract, but the court found that, in most circumstances, it would be assumed that the parties intended for one system of law to apply to that contract. Does anyone else have anything to add to this?
Not presently.
There's one final question then that we have, which was, how does the UK Supreme Court's decision compare with those of other jurisdictions? Who wants to pick that up? Ben, do you want to kick off since you're in another jurisdiction?
Very quickly, I'll make a comparison with the position in Singapore. I think it's probably fair to say that the decision of the highest court in Singapore, decision in a case of B&A and BNB, which I think was 2019, In substance, it's very similar. At the margins, perhaps there is some differences, but those differences are almost certainly due to the different sorts of facts that were being considered in the cases. The courts in Singapore have been quite happy to take a more proactive approach, if it can be called that, to seeing a express choice of law clause in a main contract as extending to an arbitration agreement, perhaps a little bit more historically than the English courts. And there was a first instance decision in a case called BCY and BCZ, which we referred to, where that was given quite a strong shot in the arm. I think it's probably fair to say that even though the decision of the Court of Appeal a few years later was written by the same judge, there was a slight rowing back from enthusiasm for the strength of that point. But then Enka has come along with a very strong endorsement of it. So there may be a little bit of a difference in nuance between those. Another issue arises as to the circumstances in which a court is entitled to displace what would otherwise be the proper law by reason of the validation principle. At least the majority in the Supreme Court and Enka have said that one should do so, or one can do so, when there is a serious risk of the arbitration agreement being invalid if you don't apply a different system of law. In B&A and B&B, the Court of Appeal decision in Singapore, it seemed like the Court of Appeal may have put the threshold for intervention a little bit higher. It may have put it on the basis that one would intervene only where it was clear that that not applying the validation principle would undermine a clear intention to submit disputes to arbitration. Now that was obiter, ultimately that was obiter in the case in B&A and B&B, but it might reflect that there are different nuances of approach in Singapore, but I'm not sure whether those will be borne out in cases on precisely the same facts.
If I could just very, very briefly comment, Ben, on your analysis of B&A and B&B, I think it's important to bear in mind that the issue in B&A and B&B was what was the seat of the arbitration rather than what was the proper law of the arbitration. And ultimately, the court decided that Singapore was not the seat, and therefore they didn't actually go on to decide the question of what is the proper law of the arbitration agreement. So I think I would be careful to extrapolate from the decision of the Court of Appeal in B&A and B&B as to how they might treat the proper law of the arbitration agreement.
You're absolutely right, of course. But the courts below did deal with the proper law issues, and the Court of Appeal did consider it. Why it didn't really arise at the Court of Appeal is because the Court of Appeal held that the proper law of the main contract was PRC law, and that the seat of the arbitration and therefore the law of the seat was also PRC law. So there was no scope to apply any sort of validation principle because there was no competing law that could be applied. The only law that could be applied, whichever way one looked at it, was PRC law. Niraj or Philippe, any interventions?
Not on that, but we do have another question on the validation principle and whether it operates in a binary fashion. And just to explain that, the premise of the question is once an issue of invalidity or scope comes up, engaging the validation principle is the only possibility to move the law of the arbitration agreement from one to another. I think maybe kicking that off, but it's a fascinating question. Sul America, which Niraj discussed earlier, is quite a good example of that. So where I think there would be agreement about the validation principle coming in is where a presumption in favor, like the one in Enka, of applying the law of the main contract on the facts of Sul America, quite clearly Brazilian law, would lead to the entire machinery of arbitration, which was on the face of it, clearly intended by the parties, falling apart. So I think sort of as a short response, I don't think it's binary. Validation, I think, comes in as a factor, say, in support of the law of the sea or another competing law, if there is another contender, which upholds the arbitration clause. In the English cases, the main competition has always been between the sort of expected or putative law of the main contract and the law of the seat, but it doesn't necessarily have to be binary. And indeed, the validation principle might actually reinforce the law of the main contract in case the law of the seat, for example, would pose a certain concern. I don't know whether that's correct, but I don't think it's clear cut.
Yes, if I can just pick up on that, I think, Philippe, you're right. Where I sense there's perhaps a hole or the Supreme Court decision doesn't cover this situation is where there is no express or implied choice of law. Generally, it will be the law of the seat if a seat is identified, but there isn't a backstop. So it doesn't seem to me that you can read from any of the Supreme Court judgments that the validation principle applies where there is no express or implied choice. The law of the seat might invalidate the arbitration agreement. It may be, the validation principle only stretches so far. There are going to be some clauses, some agreements that are simply defective, pathological, cannot be saved. And this may be one such situation. The validation principle, as I read the judgments, only kicks in where there is an express or implied choice of law, and that might invalidate the arbitration agreement, not where there isn't an express or implied choice, and the law of the seat is specified, or the seat is specified. There's no provision there for the validation principle as I read the judgments. So that may be a gap. It may be, like I say, unavoidable. Some agreements simply can't be saved.
One other point just to add in answer to that question. I think that question also asked at the end whether there was a situation where the validation principle might apply to validate parts of the arbitration agreement and leaving other parts to be determined by the law of the seat. And I don't think that is possible, because what I think almost everyone agrees with in this area is that there is one proper law, the arbitration agreement. And the question is how you get there. And once you determine that proper law, there is that one proper law. And the way the validation principle applies is that if the possible proper law may invalidate the arbitration agreement, and the validation principle says you choose one that does validate it. I think we're slightly over out of time, but we did tantalize the audience with the question of what we would advise in terms of drafting in light of the Supreme Court decision. So perhaps we could just deal with it very, very quickly. Ben, do you want to kick us off on this?
Sure. I sort of asked myself the question, having read Enka a few times, how does it benefit me as a practitioner? And I sort of took it in two ways. One, in terms of drafting arbitration clauses, but also in terms of the advice that I'm going to give clients when an arbitration agreement comes before me. I'm going to do the latter of those first. I think that the net result of Enka is that it certainly makes our job as advisors when disputed issues as to arbitration agreements come up a fair bit easier. There are some differences of opinion on the margins in the Supreme Court decision, but generally we have, for most cases, now a very clear roadmap as to how to approach the issue as to what the proper law of an arbitration agreement is. And quite helpfully, at the end of the majority judgment of Lords Hamblin and Leggett sets out, I think, 10 or 11 numbered subparagraphs, a summary of their judgment, which I'm certainly going to print out and have next to me every time a law of the arbitration agreement issue arises. And my starting point is to be able to go through those. So in short, I think Enka is very good for us when we come to advise our clients. So very good for clients, perhaps less so for us as practitioners wanting to make more money out of disputes over these sorts of issues. Just one or two further points. It seems to me that what I take away as the most a telling feature of Enka on a practical level is that we ought to give full weight to express choice of law clauses in the main contract. And there's perhaps been a recalibration of the way we think about the proper law of the arbitration agreement to bring that law more in line with the main contract. So I think perhaps there's a recalibration of the starting point. A second point, quite a different point, but still important point, that is perhaps brought out more in the Singapore decisions than the English decisions, but for no particular reason, is at the end of the day, there are bad, pathological, hopeless clauses that simply do not work. We should not be too concerned about that. We are, at the end of the day, construing contracts, and sometimes parties, for good reasons or bad, come up with a contract that simply doesn't work. The validation principle certainly has a role in minimising the situations where we come to the conclusion that a clause is so hopeless effect can't be given to it. But if, notwithstanding application of a reasonable view of the validation principle, we come to the conclusion that a clause is simply bad and does not give effect to the party's intention to submit the disputes to arbitration, so be it. It's not something that we need run away from. In terms of drafting clauses, I will just make a few short points. First, of course, we have to appreciate the context in which these sorts of clauses are negotiated. We all know they're called midnight clauses and so on. I suspect in many cases they're dealt with a little bit more sophistication than being done at the very last minute at 1 minute to midnight or so on. But I think what we read from these cases, what we understand is that simplicity in drafting is the key, and that a well-written, well-considered arbitration clause is unlikely to give rise to any problems at all. But if we don't have that time, or there might be countervailing considerations, and there's perhaps two. If certainty of outcome in terms of what law is going to apply is the key, then a simple express choice of law clause or choice of law provision in an arbitration agreement must be the way to go. Simply saying this arbitration agreement shall be governed by English law. So if certainty of outcome requires the application of English law to that issue, that's the way to do it. A well-worded governing law clause in the main contract and some supporting words in an arbitration clause will be the same effect. But query whether that form of certainty is the only virtue. It may well be that the certainty that is being sought is that there shall be an arbitration, and which law governs it may be of secondary significance. So in those circumstances, there may be something to be said for not including an express choice of law clause in the arbitration agreement itself and leaving it open the possibility of the application of a validation approach where the application of the law of the seat approach or the governing law of the main contract approach leads to a conclusion that the arbitration agreement would otherwise be invalid. So there are perhaps some competing considerations to bear in mind when drafting clauses going forward.
Thank you very much for that, Ben. I think I've got the task of closing this webinar, so I'm going to take the opportunity also just to put in my parting words on this question of drafting points. I think many people, after the Sul America case, many people started advising that the best thing to do with dealing with this difficult area of law is to put an express choice of law within the arbitration agreement. And many arbitral institutions also starting putting into the model clauses a provision for an express choice of law for the arbitration agreement. One standout actually was the SIAC. And I wonder whether the reason for that was that sometimes an express choice of law could actually end up invalidating the arbitration agreement, and an express choice of law would make it much more difficult to apply the validation principle. And I know that some people argue, possibly you could still argue that an express choice of law, a validation principle could still apply to an express choice of law on the basis that the parties couldn't have intended that express choice of law, but it does get a bit strained, I think, at that point. So that leaves me with a thought as to whether, given the clarity that we've got from the UK Supreme Court on the implied choice of law of the arbitration agreement, or importing the express choice of law of the main contract into the arbitration agreement, whether it might in fact now be the safer option not to put an express choice of law in an arbitration agreement so long as you have an express choice of law in the main contract, and you're quite happy for that to apply to the arbitration agreement, save in the situation where perhaps for some unforeseen instance that invalidates the arbitration agreement. So unless my colleagues want to add anything to that, then I think the task falls upon me to thank everybody for joining us today. For those of us who are still here, for staying on well past the hour, thank you very much for your interest in this topic, which is obviously something of great interest to us. And as Ben said, if we get another UK Supreme Court decision arising out of this, you might well see us coming on again to give our spin on it. Thank you very much. Thank you all for joining us. Good day to everyone.